Chama Wontumi latest updates and I said the breaking news on the train say bebro because the train court in the ruling on the beba and because court ni share and yeah 29th June say will be tea application mo file share or more extension of time na ni new layer cancel attaching na on ready proceedings on tron what the submission na omoma final ruling July 10 ebusua na no copy mo no na ye hwe se there ben ensem na court no beba na operation recover all to mo paint and ensem we drop it first nti ye any the kind report was am na ma wa ye YouTuber say nti fast forward the screen and we operation recover all it was a court update summer boy case no and omko more appeal on the court say omo extension pen na making kind in a court no my lord at the buy no Chama Wontumi yam ashini pa na nyina say was a republic versus Benedict and Tugosia ko Chama Wontumi and two others summer boy illegal mining case. The court, after listening to the counsel for the accused and the prosecution, has granted an extension of time from today day 29 to 13th July for counsel for the accused to file an written address he may have. Consequently, the court has set a new date, 20th July 2026 at 9 o'clock in the 4 afternoon to deliver its judgment. Let's just say your money bread, your money 2 weeks. Let's say your money 3 weeks. Your money 3 weeks, you know. Our penman 3 weeks say on fanko na on conking can court proceedings na a year 20th July court to be money final ruling. We any sembia a free a court ever. Life have the Chama Wontumi. I am actually stay tuned for more details.
Na sebio ode eka asem no if you say judge nankasa no asem a ogina mbraso edi ruli eye apiaku bi asem no san asem no ye de ehu ni say san asem no eni enchia ye ansem a eda ho egina ne naso a wo say judge no ontwe ne ho mfiri ho intanje dwumadwumadie ma Ghana fo nyina ate ensem na se na be ya ochina no de be free court aba no ye nyina no sebio yakoma ebeto eyim enti ejumbre hwame I would like to say thank you very much for tuning in. I'm very happy. Step back a little bit. This issue I can is got to do with a chairman Wontumi. Last week, what actually came up? Wontumi Samurai Boy trial. Wontumi's lawyer Samuel Atachia has urged the high defer judgment beyond 3rd July 2026. Now, citing the registry's failure to furnish him with the record of proceedings needed to file his written submission by the court ordered deadline of 23rd of June. Now, last week, Atachia said, they say, the new lawyer, Emma chairman Wontumi. Now, Sisiano, or no, I catch record to say, even though court, I catch and say, Onko, now Onko Jinkratana, a proceeding documents, no, now on study. In fact, Nanka was a court no, on the 17th of this month. No, and I just think on a year written submission be a free a year the defense counsel. But because Chairman Wontumi ebe catch a court to say, or no, a year Chairman Wontumi no, or ne appear could be any maybe because appear could be Jimmy no. The court actually said to say, even though an imbrem say or say appear could be back court, ebe catch and say on a Chairman Wontumi Jimmy because or then the rented Chairman Wontumi and answer or high or decides ordinance or render the services amateur Wontumi. Inti see on the Chairman Wontumi Jimmy be ma. The court has nothing to do with it. But the court, out of respect for Apia Kubi, and also not to look like they are preventing Apia Kubi from explaining himself why he's not a counsel for Chairman Wontumi. No, the learned judge actually listened to Apia Kubi's vague statement in court. Oh, we are not the answer to us. Okay, so Chairman Wontumi akofa a lawyer for attaching. What she said, I want to rule him say. A year from the 17th, we move the 23rd. Now, a year attaching or the new lawyer for Chairman Wontumi, on to make sure send a written statement, or their back. Now, remember, judge in that day, or a ruling be. Now, ruling here very important. The reason why the ruling is very important to Ochina Court or Moko and the Chairman Wontumi judgment, and then say, judge the ruling, she was specific on some things. She was basically emphasizing on Nyomebia and to me affected the 3rd of July, a year next month, a year ruling. Inti those are not that ruling here very important. I will say yejina adwene ekosi. Obeka said na Sunday Kevin ekasa asem asem because Ochina something might happen in court. And when I say something might happen in court, and I say meaning BBC, but I'm trying to let you understand what Chairman Wontumi and then the lawyers so they are trying to do. I want you to understand what they are doing and why court is supposed to be very careful dealing with Chairman Wontumi and the lawyers, because the abuse of the court, by Chairman Wontumi and then the lawyers from day one, it has been there. But the court, for some reason, Ama Chairman Wontumi and then the lawyers too much room. And my fear is that at a point, sir, abuse Chairman Wontumi and then the legal team abuse the court, it will set a bad precedent. Some lawyers in the future might capitalize on the court's generosity. You see, the court, Samurai Boy case, criminal case, I believe said the court has been very generous. And when I say very generous, there are so many things that the court, in Isanka or more money secret during the trial. But for some reason, the judge on the case decided to give the accused all the opportunities to exhaust every opportunity. Send a beya, Obinko Jina Bebinka say, Nambe call court, and actually, I won't win the lawyers because say, your call court, there were some things that were not in our favor. And a court, I believe we say the court has been very generous, but the generosity in a court, show Chairman Wontumi the lawyers, they are abusing it. Now, appear could be the status are abusing, They have abused the court for a long time. Now, there's one thing. Say, court, they decided, say, because they want to give Chairman Wontumi the opportunity to, at the end of the day, defend himself. Now, court, and she say, abusing the area too much, There are other legal brains. There are other people in court. There are other people who are also facing their criminal trials. They are taking note of the court's generosity. When it comes to legal matters, there's nothing like generosity. What the law is the law, basically. That's what I'm trying to tell you. The law is the law. That's why when people go to court, when lawyers go to court, they use acts. They basically base every statement they make on a precedent, on facts, because court is not a place to speculate. Now, the moment you give people the room to abuse the court, even you being generous, you are creating another avenue or window for somebody to also abuse the court. And sometimes in court, or because judge way there, judge way on judge way, because the reason is that the moment you try to be generous, not biased or trying to allow somebody to walk free, the moment you try to let people feel like they also have the right to express themselves, defend themselves, the more you become generous, the more you do what? The more you create room for the court to be abused in the future. And that is what I have seen over in fact, since Chairman Wontumi case in start here, the council and our lawyers of Chairman Wontumi from Apia Kubi, Ebesi Atachiano, they have seen abusing the court, because the court allowed them to do that, Apia Kubi cry free hono, Chairman Wontumi Ekofa Atachian, he also wants to do that. And that is dangerous for Ghana's court. It's dangerous for the judiciary. It is dangerous because other people are watching, other lawyers are watching. Now, there are two things you need to look out here. Or see a judge ruling before Atachia was brought in as the lawyer. And secondly, how Chairman Wontumi, your static case with criminal case with na appear could be a lawyer, how they have abused the court to this point. Now, my main show idea. Recently, Ohona Atachia ever grantee interview. Right now, Atachia is the lawyer, Emma Chairman Wontumi. Team, stay with me. Sorry. Atachia ever grantee interview, Atachia said, Samurai Boy case, 6 weeks will be enough for me to prepare my written statement. As we sit here, Atachia is going to go to court tomorrow and ask for 6 weeks. Almost 2 months. That is 6 weeks. 1 month, 2 weeks. Ninyana say, or see obeko court or china no plead with the judge and say, man is 6 weeks. Now on study case from day one. Court day 1, day 2, day 3. All the documents that were shared in court, case management period, a year witness statement, or say, judge na a man is 6 weeks now on to me reading. But remember, say a man is 6 weeks not already signed your way no EBBA. Rating submission. After that, does it really matter here? Is it very important? Does it have any effect on the judgment? That is the question we need to ask. Say, am I touching 6 weeks? The question is, 6 weeks there, the man no. Oh yeah, what is the end game? The end game is written statement or written submission or written address, whatever. And that is his opinion. Now, at this point, does it really matter to the judgment? Does it really matter? Will it change anything? What did the judge now or case now about written addresses or submissions? Written addresses or submissions, no, does it really matter at this point? Now, before we continue with this 6 weeks, chairman Wontumi lawyer attaching the strategy they are playing to delay the case, not for the case to even be judged this year, no. Let's step back a little bit. Now, Mukai say case in the question BBC, and these are some of the abuses I'm about to show you. Make sure case in the question to many appear could be abusing court, no. For some reason, the court actually did what? The court allowed it to go on. And I'm not saying the court allowed it to go on in a bad way. The court basically felt Sheba Wontumi needed all the time to make his case. But court now allowed that, no. What Chairman Wontumi lawyer Apia Kubi ABC Atachia did, and they said they abused it. Making sure say sa chance na court dia mom no be say no de be gu court no hu fi de be kire say court no mumbu no. Now let's step back a little bit. This is a court proceedings. Me. Now proceedings we know, and this is what happened in court. It happened around the 3rd of June, all the way 3rd June. Satana case no koso. Now you see this document, it's public document, and a court. You can go to court tomorrow, they'll give you all the documents. We can also publish this tomorrow. This is not Kevin Taylor's document, and this is a document, 3rd of June. I said, Miss your court. That is how Chairman Wontumi and then the lawyer Apia could be abuse the court, no? And so the Atachia wants to do that from tomorrow. Now, that's 2 p.m. Date tonight, 3rd of June. And so accused persons, A1 presents and present A3. Sorry. Present and represent A3. Now, the counsel, Dr. Justice Srimsai, or the Deputy Attorney General, basically, he was also the lawyer for Ghana. Let's make it simple. Now, so we study should you see a timer na case in the course and see how Apia Kubi, what he did in court. Any judge be only abutre, any court be they don't want to even listen to Chairman Wontumi no. Anka Apia Kubi that time ni no anka ka ushebupa nanke this case do this point. But all these things, Chairman Wontumi and the lawyers, they never spoke about it. All the things they did against the court, all the deliberate action they took, no munim say it was going to delay the case. The judge still had that had to accommodate. Could do point to be a judge be a say be one person be chairman want to be a the ding person or quick or judge asam no anka say be obegina sa adwuma ne so nyina judge asam no but judge ni nya abotre o wiase nyina ama chairman want to be Emma Apia Kubi any chairman Wontumi mo disrespected court on several occasions, but the judge still believes say it was a chairman Wontumi enya fair hearing. Fair trial is very important because he is just an accused or yet somebody who has done it so far as we speak. But so when you are now come back into court proceedings, now share idea Apia Kubi deliberately or court. Na judge na ko say the bufu. Now I say no. This is too much disrespect. Eye de nimtia no doso. Just say we are lawyer penyin a wudi Chairman Wontumi enim but dia wo ye no I say we need da ho na opese ubu court enimtia na wudi di Ghana for the atem. But what happened was that judge did not do anything. And when I said did not do anything, the judge could have stopped the case there and said, hey, Muni BBI, the way you are disrespecting the court, and I want to go ahead and write my judgment. But the court accommodated them. The judge sat and did not even react until at a point, Judge said, no. The abuse is too much. You see, to the point, after Judge said, this is becoming like a strategy of Apia Kubi Chairman Wontumi. And to the judge at a point, in court, the judge made it clear to them, said, no, the disrespect to the court, the disrespect to me, the disrespect to Obiano, deliberately a counsel, and as a lawyer, deliberately changing things even in court. Case management or to be back court, all of these things, judge can say, what Shasha would say, Apia Kubino, or a lawyer be I just say on canocre, I just say, delay case, because in technical judge will be bias. Now I the cell, pursue jelly chairman Wontumi, and case in Kendruha. But this judge feels to say, Chairman Wontumi needs to be heard. Chairman Wontumi, the witnesses are supposed to come. Chairman Wontumi, whatever is provided, we need to. But it got to a point you could see, say, Chairman Wontumi and Apia Kubi, they were deliberate in their actions. They wanted to abuse the court. On per se, almost say case, you know. And I'm doing this and I say, that is the same 442 formation and at the end, attaching a picky free. They just want to delay the court. They don't want the judgment to happen. It was attaching us also called court or compare 6 weeks. On for study documents. Abra case near KWA. Now, my mention you see a court and why attaching to me, respectfully to the court, with all due respect to the judge, I believe attaching is not even supposed to be heard tomorrow. That is what I believe, myself and my team. I believe, say, the disrespect from Chairman Wontumi Council 1, Council 2, no, it is too much. And the same strategy, the same thing I attach Champesoye. And I believe, say, the court is not supposed to tolerate this. Now, you see, when you read on the 3rd June proceedings, you ask yourself, say, but why was the court allowing this? Now, Mami Ridi Adewincho, this is what happened in court on the 3rd of June. Oh, sorry. On the 5th, right? On the 5th. But the judge had to address Adibia, Apia Kubini Chairman Wontumi, Ababe P attaching, so attaching is doing same. And that is the most dangerous part in this case. Now, Hadia, let's take our time and go through what actually happened in court. And these are some of the things that Atachia is asking for. And these are things that are documents that he can even go to Apia Kubi and demand. But because he wants to delay the court, he wants to abuse the court, that's why they are doing this. Mama Cho, before Ochina Omako Court. Now, on the 5th of May, 2026, this is 5th May, near June Crow. Now, they see a court. The accused person filed 2 witness statements out of the 5 witnesses they listed. Now, on the 6th May 2026, the accused person filed another witness statement, making 3 in number. They, however, informed the court of their intentions of filing 2 witness statements in addition. The court conducted CMC on the 3 witness statements and proceeded with the trial with the anticipation that the 2 witnesses, the other 2 witness statement will be filed by the accused person before the end of cross-examination of the other 3 witnesses. So, I'm file witness cases, witnesses say instead of 5 statements, was Adani 2 and Adani 3, and this is what transpired on the 5th on the 6th of May. Now, don't worry, however, at the end of the cross-examination of the 3 witnesses, the accused person had not filed any additional witness statement. Go ahead still. And then they did what? They cross-examined the 3 witnesses from Chairman Wontumi. Now, the funny thing is, time cross-examining of the 3 witnesses, the accused, Apia Kubi, they had still not filed witness statements of the other witnesses. Now, the court cautioned the accused persons and gave them 7 days to file additional witness statements if they are so minded. Into my court bufuye, judge in bufuye. And I can say Apia Kubi. Sanko fuya, I will say Obabe witnesses a match ma Wontumi. Miame Babe warn you say Omo Empe Omo Wasema, Omo Branome file state because on paper, the CMC case management, actually say, I was some file near to be called any more case. Into my judge bufuye or court. And I can say, Diamoyano, Nyanse Bienim. Yako case ni na ho adwuma behind the scenes say nipa dodo say na ebe kasa we na beto yebeduru pe na wo Apia Kubi ne Chairman Wontumi enkofo wo so mbe kasa no na sebio yehu bebi omnam omo statement so omo famba enti why how are we moving forward and all this the judge had the patience to listen. So at the point the judge said no, I need to send a caution to omo jatum so mbe witnesses for Chairman Wontumi. Now, this is what happened. On the 25th of May, so from the 6th, the 25th of May, something happened. On the 25th of May, 2026, the accused persons filed a 4th witness statement in the name of Honorable Kobna Ochredaku Mensah. The court conducted CMC on this witness statement and proceeded and proceeded and adopted the evidence in chief of the witness. Cross-examination commenced. The mouth of the witness was sealed and matter adjourned for continuation of cross-examination. Right now, naka witnesses mienu Chairman Wontumi appear could be filing. So judge in mass a question no. I will say judge the boo fuba no and the back by so yet back waba. Na bakun na ye gabi kobi ochredako the former Western Regional the minister akwana the nise petuo no gibi no no. So when the guy came to court no they see and they say appear could be more making sure say one kasa cross examination you better to the witness no appear could be any chairman want to be by no almost so effort strategy be say witness no and he say obi na no kasa almost selina no almost person obe answer to anything and that day no ye ntwe ndi dwuma bia or court and a court case you know something let's adjourn ye two case ni sheda. They use another technicality to prevent the witness from speaking. When they were in court that day Saturday ni so no awosanka kobi ochidako attorney general in samano no ono so te obudin yebusa na ono so person bekasa ema o waste time ema appear could be use delay tactics for court eka say because of something me client into me kasa because of ema akwa no sorry kofi ma yentumi antena case ni so ema judge ni sa to case ni sheda because the time not time na court. And remember from the 5th of May judge ni tumi nya aden abotre for all these things. From the 5th of May to the 25th of May, no, anka witnesses ni anka crosses are minimum, but appear could be deliberately or making sure say a court no schedule no or best schedule no because he wanted to delay the case. He never wanted the case to end. And these are some of the things they did in court. And the ABPH a year attaching us to picky from here. So I just say a baton. We echo kakra no da come away. Now we have delay. So it's a delay strategy. Now the same court, I'm sure their course is here. They see any before continuation of cross-examination, counsel for the accused, that is Apia Kubi, person informed the court that, let me take this, before continuation of cross-examination, counsel for the accused person informed the court they had filed a supplementary witness statement in respect of the same witness. In terms of our court, I feel that Apia Kubi catch the court to say, kobi ochedako. Or the statement I had tuma yebebusebusa na no asem no appear could be say was filing another statement akasa statement no home until say yebeje sa statement na tumu no sa kobi ochena ko ntumi nkasa. But remember answer na witness babet na dakem na ebusebusa na no nsem no ye free BCMC judge no on it 2 lawyers no ehia behind the scenes no mo nyina age questions ebe bubusa nipa no atum ye wi a na ye de ama court no eno na ye dru court ebedi hu nkomo. Now what appear could be did and say statement na kobi ochedako edin kan attended in say enuna the witness statement attorney general ebe hwe so to na no ade chi bi no metena court appear could be catch the court say ne witness no esa another statement bi or person de saka the statement no meaning sa first statement na da no yentumi ndi ho adwuma yensan ko biem ne enko another CMC case management behind the scenes na first supplementary statement in san can the witness statement no meaning it's a clear strategy to delay the court. And all this while na judge no won't show any anger. The judge was still accommodating Apia Kubi ochirakuba first time almost silina no mama nankasa Apia Kubi appear could be catch record say oh me witness no one send be can rempo afinti side be ka ho na eno no because court engine to munti they are not going to allow a cross examination omo pese court ne gin supplementary edien na asam ne saka ho ansa na yato so meaning the delay tactics is in force. They just don't want the case to move forward. Make sure the delay of my bedroom na omo abuse court na and the court should not allow Atachia to even make a statement in court. The judge or the court should not even entertain Atachia because Adia appear could be a year from day one basin. That is what Atachia is continuing. And it's also 6 weeks. You ask for another 10 weeks. Now, Mamichiro abuses Nibi. Now, so when this happened, now the judge started getting frustrated. The judge started getting angry because it looks like say the taxpayers' money every single minute we are judge we are basically paying the judge. Every minute we are general court, we are basically paying them. So the judge is like, you know what, the taxpayer We cannot waste their money like that. We need to basically move on, do the thing. I said the piano, I appear could be chairman want to be bar, witness crab, witness about another document, ya printed document, obedience away the Busan question, or the witness so a kai bibi, in Tiesiano, yen to mean Cassande, yen fanko count and son and witness nakasa. Now the judge, something happened. Now, notwithstanding his, so this is what happened. Notwithstanding this irregularity, the courts obliged and conducted CMC on the supplementary witness statement and proceeded with the trial. Inti appear could be by and so yes, I was statement be a could be account and agree into a account and I consider no problem. Say mo per se supplementary a you can one court to because we cannot make this thing delay the case. Yet to be must have supplementary with statement we end delay case. Into the judge was patient, and the judge said, you know what, we whatever you want to do, we will accommodate you. So the judge accommodated the